Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. The popularity of legal shows like People's Court has sparked interest in the real live counterpart of it, which is small claims court. Today we'll talk about how to bring an action in small claims court and whether those decisions are legally binding. We'll also look at some of the proposals in the legislature to improve the housing court, which last year alone handled over 200,000 landlord-tenant cases on its calendar. Our guest is the Honorable Jacqueline Silberman, Administrative Judge of the New York City Civil Court. Hello, Judge Silberman.
Hello, Alan.
Judge, how can one get into small claims court? What do you have to do to get there?
Well, first you have to have a claim against somebody who either does business or lives within the city of New York, and then you go down to the courthouse of your choice in one of the 5 boroughs, and usually the one you live in, or the one in which the transaction took place.
In other words, I have a choice. If I went to a cleaning store in Manhattan, although I live in Brooklyn,
you could go to the Brooklyn Small Claims Court. And you go down there, and there will be clerks in the small claims part who help you fill out a summons and complaint. You pay the money, they mail the service for you, and there you are with an action commenced in small claims court.
How much does it cost?
$5.
Now, do I need a lawyer?
No, you do not need a lawyer. Most litigants in small claims court are pro se. Most claimants are. Some defendants come in with lawyers, but most claimants are not. The moment there are 2 lawyers, you would be switched to the regular session of the civil court. It would no longer be a small claims.
Well, does the judge help me try my case? I mean, how do I know if I'm just coming to court? How do I know what to bring with me? How do I know how to present my case?
Well, in the clerk's office, we have a bulletin, a guide to the small claims court. We have it in both English and Spanish, which will help you try your case. Of course, once you get down to court, if you haven't read the booklet, the judge might help you, or you may go before an arbitrator. Indeed, most cases are tried before arbitrators.
Okay, let's stop there. How do I know if I get an arbitrator or a judge? Is it my choice?
Yes, it is your choice. Only by consent can the case go to an arbitrator, only if both sides consent, both the plaintiff, the claimant, and the defendant. If both the claimant and the defendant do not consent, it's tried by the court. So if one asks for the court, it's tried by the court.
Okay. What are the advantages of going before the court or a judge, and what are the advantages of going before the arbitrator?
The advantages of going before an arbitrator are a swift and speedy trial because, of course, the judge can only try so many cases in any given evening. So you may have to come back in an evening if you ask for the court.
Okay. If
you ask for an arbitrator, however, your case is not appealable. There is no appeal from a decision of an arbitrator. There is no record of the trial before an arbitrator.
Well, how much can I sue for in small claims court?
$2,000 is the jurisdictional limit right now.
Well, so in other words, if I don't like the judge's decision, I can appeal that.
That's correct.
But if I don't like the arbitrator's decision, I'm stuck with it.
You are bound by that decision.
What if I'm a corporation? Can I sue in small claims court?
In January 1991, you will be able to sue in small claims court. There will be a commercial small claims court. But right now, you cannot sue in small claims court.
And again, talking about that commercial small claims court, can one corporation sue another corporation in small claims court?
Provided it's within the jurisdictional limits of $2,000.
And that $2,000, is that also applicable for Nassau County and Suffolk County and Westchester?
I'm not sure of their jurisdictional limits as administrative judge of the Civil Court of the City of New York, but I believe so. In Nassau County, they already have a commercial small claims. They allow corporations to sue in small claims court. We do not at the present time.
Let's discuss the common matters that come before the small claims court. I know certainly motor vehicles and property damage would be one of them.
That's correct.
If my car is damaged, let's assume it's damaged on the usual fender bender, and the insurance company for the person who hit me doesn't want to pay.
Or the person isn't insured. Or you're suing perhaps the garage that repaired it or something. Any number of reasons why you would be suing in small claims court for under $2,000.
Now, how do I prove my case? I have my property damage. My car is damaged. How do I prove it?
Okay, did you or did you not repair it? If you've already repaired it and gotten a paid bill, you bring that paid bill with you to court, and that will be proof that you had the amount and that it was the fair and reasonable amount for it. If you haven't repaired it, let's say you don't have the money, which many people don't because they don't have insurance to cover it, and they come to small claims court, they couldn't make the repairs for $1,000. So what they have are two estimates, and they bring those two estimates to court with them, and that will be taken by the judge as proof of the amount of money for the damages.
What about pictures? Should I bring pictures of the car?
That would be very helpful to a judge. I know some arbitrators who consider that very important in judging whether the fair and reasonable amount of the damages is what the estimate says they are.
What happens if which happened to me, I brought my suit into the cleaners, and I come to pick up my suit, and he says, well, we don't have your suit. Or they return my suit and it's damaged. What can I do then?
That's one of the very, very common claims in small claims court. You come and take a small claims summons against your cleaners. Of course, if they don't return it, as you and I know, and people out there may not know, that's a bailment. So you would only have to prove, here's the ticket, I brought in the suit, and you probably, if you have a bill from Saks Fifth Avenue or from Mearns or Sims or any other store as to where you bought your suit and the price, or how long you've had it, you testify what you paid for it, and the fact that they haven't returned it, you have a suit.
Now let's talk a little about housing court. I know that, in fact, someone told me that you have over 600,000 matters in your court alone per year.
That's in the entire civil court of the City of New York. That's the small claims court, the housing court, and the regular part of the civil court. In the landlord-tenant court, the housing court, there are about 200,000 cases a year.
Well, certainly when we said in the opening, yours is the people's court.
Indeed, it's a court that many people, it's the only court they ever see, is the civil court.
Person is served with a summons for eviction. Summary proceedings. What do they do?
Well, the thing they should do is right away come down to the court to file an answer. They can do that in the clerk's office at 111 Center Street, if it's New York County, or at the clerk's office in Brooklyn, or in the clerk's office in Bronx or Queens.
Do they need a lawyer?
They do not need a lawyer. Over 80% of tenants are pro se in the courts.
Let's assume that
if they can afford a lawyer, it would be very nice.
Let's assume the person is received, the landlord wants to evict the person because the person hasn't paid their rent.
That's correct.
And that's true. They haven't paid their rent. Well, what can happen then? I mean, will they be evicted? Will they be thrown on the street?
Hope not. There are lots of defenses even to a non-payment. There may be the warranty of habitability. Maybe the landlord hasn't made certain repairs, and that's the reason the person hasn't paid the rent. Maybe the person hasn't paid the rent because the building has changed hands and they don't know to whom to pay the rent at the present time, so no proper demand has been made. There are defenses.
We have to take a break now, but let's go into those defenses right after this break. You're watching Lawline. Stay with us.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors, or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
Lawyers, like medical specialists, limit their practice to certain areas of the law. At our firm, Zalman & Schnorman, we specialize in personal injury litigation. We concentrate on helping injury victims receive fair compensation, and there is no charge for our legal services unless we are successful. If you are too injured to come to our office, we will come to see you. At Zalman & Schnorman, we care about you.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all this lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
Hello, you're watching Lawline. Today we have Judge Jacqueline Silberman. Judge Silberman is the administrative judge of the New York City Civil Court. And we're discussing small claims court and housing court, the People's Court. Judge, you were just going into the defenses a person can have when the landlord serves them with eviction notices, they haven't paid their rent, they don't know what to do, and you were just about to tell us.
Well, we were talking about the defense of the warranty of habitability. There is the defense of lack of service. There are possible defenses that a proper demand hasn't been made, and other technical kinds of defenses, all of which they could file. If what they're really looking for is time to pay the rent, of course, when they come down to court in conference before a judge or before the mediator, time to pay can be arranged. Indeed, we have also income maintenance people from Human Resources Administration located within the courthouse to help people who either need welfare payment or just need a one-time payment to help them over a bad spot because they couldn't pay their rent. So everything is done not to evict a person in the first instance.
Judge, I was interested. You said about offsets. Now let's assume the ceiling is peeling because of water damage, there's water leaking into the premises, and that I've notified the landlord continuously, and my rug is getting wet, and there's mildew smell throughout the apartment. In fact, the plaster is actually coming down. Could that be some sort of offset?
That would be an abatable condition under the warranty of habitability, and then the judge would listen to how long this condition has lasted, what kind of inconvenience it poses, and judge as to how much of an abatement on the rent to give, whether to give 5%, 10%, 20%, whatever the judge determines, depending on the facts and circumstances of the particular case.
Now, what if I never received this summary proceedings, the summons to come to court? What happens then? Do I just get automatically evicted?
Nobody can evict you. It would be an illegal eviction without a proper proceeding to evict you. That would be an illegal lockout, and then you would come to court if you've been illegally locked out, and you would come to court and file papers in court on an illegal lockout, and the landlord could be subject to treble damages on something like that. So landlords don't do that as a general rule.
So if a landlord threatens the tenant that unless they pay the rent, I'm going to literally lock the door on you and change the locks, that's not going to happen.
Generally speaking, that will not happen. I mean, there have been instances of self-help and illegal act. We can't account for all illegal acts, but that is an illegal act.
So then I could possibly bring an action against the landlord for 3 times my damages.
That is correct.
If I went in and had to rent a motel room at the Holiday Inn, the landlord would be responsible for that?
The landlord would be responsible for that. The landlord might be responsible for putting your furniture out. The landlord might be responsible for the fact that you have to take another apartment that costs much more in rent. There are a lot of ways that damages could be calculated on something like that. By the way, you were talking about this leak in the apartment, and let's say the landlord didn't sue you and you had these kinds of conditions, let's say lack of heat and lack of hot water. A tenant could initiate an action too. There are tenant-initiated actions for repairs and for violations. Those are sort of code enforcement things.
Judge, what happens when I read that the tenants of a building get together and you see signs outside, rent strike? What does that mean?
Well, just exactly what it is. The tenants have gotten together because of certain conditions. It's a tenant-initiated act. Sometimes part of a rent strike is they initiate one of these code enforcement HP-type actions.
Can they do that by themselves?
They can do that by themselves, by coming down. Sometimes if they go to their local assemblyman or a local task force group, the task force on housing will help them in getting together a tenants committee and a tenants group to enforce these kinds of violations and their rights because of the violations. Indeed, sometimes rent strikes are just what they are. They are a tenant group withholding rent for various reasons, and then the landlord sues them, and then these actions are joined together into a collective action before one judge because many of the issues are overlapping.
Judge, in New York City, it's either every building has gone co-op, will go co-op, or some of the tenants are hoping it will go co-op. But there are tenants who are being harassed. If a tenant feels they're being harassed because the landlord wants to gain that particular apartment because it's worth more money to them, what should they do?
Well, if they're being harassed and this is causing damages to them, there are sorts of legal actions that they can take which have nothing to do with housing court. But if the landlord, in the process of harassing them, one of the ways that landlords do harass is they bring non-payment actions every time the rent may be a day late or something like that, or if they put down an extra tile in the floor, on the floor, they bring an action. Then one of the defenses, when we were talking about at the break, if you recall, we were talking about defenses to a non-payment proceeding.
Right.
One of the defenses is the landlord's harassing me. Selective enforcement kind of thing. That is a possible defense.
Is that like a malicious prosecution case where you could say the landlord is using the courts?
The landlord doesn't necessarily have to use the courts, and you don't have to prove all the things one would have to prove in a malicious prosecution case, but it would be a defense that would be considered by the judge in a non-payment action.
I know another area of concern is the primary residency issue. There are many people in New York that may have another home in Florida that they use a couple of months a year, especially the older people in February and March, but and all of a sudden they get investigators coming around. What's the story on that?
Well, in order to keep your apartment that is rent controlled or rent stabilized in the city of New York, and there are really good reasons for that, that you wouldn't want people that are not living in New York, it's not their primary residence, to have the advantage of rent stabilization or rent control when we are so needing for apartments for our own citizens. So there are reasons for it. In any event, to be a primary resident of New York, different factors are looked at. One of the factors are, where do you register? Where do you pay New York City?
Register to vote.
Register to vote. Where is your driver's license? Where do you keep your bank accounts? I'm trying to think of some of the other indicia of residence in New York.
If I vote and I pay my taxes to New York City, and I have a motor vehicle license here, but I have a house in Connecticut, I mean,
how many days a year are you living in this apartment in New York?
Now, this is not me. If my landlord's listening.
Okay. How many days a year? I mean, if you're living better than 50% of your time. Many people have summer homes or weekend homes in Connecticut. Their primary residence would still be in New York if they're paying taxes to New York, if they're registered to vote in New York, they maintain bank accounts.
So in other words, you have to be here more than 50% of the time.
That is about it.
And if I pay taxes in another state, such as Connecticut or New Jersey or whatever, you're saying even though I may live here 50% of the time, that could very well be a problem?
That may be a problem. Each case stands on its own. You understand that there are no hard and fixed rules as to which is your primary residence. There are cases that will go as to the number of days. There are other cases that will go as to whether you pay your taxes, where your children go to school, where you go to church.
Judge, right now we're in a real estate slowdown. I want to know how that affects your court. What? We'll answer that right after this break. You're watching Lawline. Stay with us.
My father taught me to steal and to pitch. Today I struck out 7 and stole home. I think Dad would have been proud. Coach was. He said he wished Dad had taken as good care of himself as he did of me and Billy. Billy won't talk about it, and Mom can't stop crying. I don't know what it's like to have a heart attack, except I can see it hurts. It hurts bad.
You can help prevent heart disease. We can tell you how.
If you are injured in an automobile or any type of accident, you may have the right to fair compensation for injuries, pain, and suffering, including loss of wages. So if an accident leaves you disabled or unable to return to your job, put our law firm, Zalman & Schnorman, to work for you. There is no charge for our legal services unless your case is settled or won. Call Zalman & Schnorman, who is specialist in personal injury litigation.
My father, Gordon McCrae, was one of the biggest stars in musicals. He was also an alcoholic. When I was little, I thought I could stop my dad from drinking. But only the alcoholic can do that. And finally, my father got help and stayed sober the last 7 years of his life. I was so proud of him. Alcoholism is treatable and preventable. Be alert to signs that you might need help, especially if you're the child of an alcoholic. For information, call the National Council on Alcoholism, 1-800-NCA-CALL.
Hello, you're watching Lawline. With us we have Jacqueline Silberman, the administrative judge of the New York City Civil Court. We're discussing small claims court and housing court. Judge Silberman, right before the break I asked you the economic slowdown, the slowing down of the real estate market here in the city. What effect is that having on your court?
Well, if you're talking about housing court, which is where we left off, and we were talking about housing court, about a year ago, 2 years ago, when it wasn't slow, at that time landlords were looking to get tenants out of the apartment rather than to get their rent. So
primary residency and things like that.
That's right. There were a lot of primary residence cases, a lot of holdover cases, and in non-payment cases, one of the deals for maybe abating rent almost altogether was to get the tenant out of the apartment. Right now we're seeing a change, and we're seeing that the landlords are more interested in getting their rent than getting the apartment because of the slowdown.
So the pressure is perhaps off the tenant as far as primary residency and items like that?
Perhaps. I think it may be a little less so right now.
What is the makeup of housing court? I mean, is it a judge in housing court? Is it a housing court judge?
Okay.
Who makes the decisions?
There are housing court judges. There are 30 of them in the city of New York, and that does not include Staten Island. We don't have any housing court judges or any housing court in Staten Island. The housing court is not a constitutional court right now. It's a statutory court.
I'm going to have to ask you, we're seen in Staten Island, and all the tenants in Staten Island are wondering, what do they have in Staten Island?
The civil court judges handle the housing court cases right now in Staten Island because there just are not enough volume of them, and we don't have enough housing court judges to give Staten Island one.
Judge, with all due respect, once I entered housing court and I found the halls were packed with people and there was yelling and there was screaming and the facilities were quite inadequate. What's being done about that?
Judge Wackler is trying very hard to confront that problem. Indeed, he described the housing court as a Calcutta bazaar, and unfortunately it is very true. We are in the planning stage of we even have the sketches for a new housing court in the Bronx. There is drawings being made for a new housing court in Queens. Hopefully in my lifetime I'll see them. That's supposed to be within the next 5 years. If we're looking to 5 years from now, certainly we'll have one in the Bronx. In Manhattan, hopefully, there was the project to build 80 Center Street. That seems to have fallen through. But if they build another courthouse for the criminal courts, then the 30 criminal parts that are right now in 111 will ease up 111 Center Street,
and we'll have more room.
We'll have more room for the housing court.
Judge, I know I told you I wasn't going to ask you any questions about the case that you tried with William Hurt.
You said you weren't.
But could you just tell me, what was that case about?
What was the case about? Okay, that much I can answer you. Sandra Jennings sued for a divorce from William Hurt, and in that divorce proceeding asked for equitable distribution, maintenance, and child support.
Equitable distribution means a percentage of the assets that Mr. Hurt has.
The marital assets, whatever the marital assets were, the assets accumulated during the marriage. His answer to that action was, what are you talking about? A divorce? We're not married. I did not decide that on papers. We had a hearing, and the decision is legend.
Well, what was the decision, Your Honor?
The decision was that they were not married. Indeed, Sandra Jennings has said they were not married via a legal marriage, as you and I understand a marriage. They did not go before a minister, a rabbi, a priest, or a judge. But she says there was a common law marriage which was consummated in the state of South Carolina. I found, according to the law of the state of South Carolina, that there was no marriage.
That's a very common term, where common law husband and wife. Do we have common law husband and wife here in the state?
In New York does not recognize common law marriage. However, New York will give full faith and credit to the laws of a sister state. Therefore, if under the laws of a state, and there are 13 of them that recognize common law marriage, if under the laws of that state you are married, then you would be married in New York.
That's very interesting. So in these 13 states, one of which you've already mentioned, if you're living together, I assume for a certain period of time.
Well, each state has its own rules, and I don't know of any offhand where necessarily a period of time is mentioned. There are things that are mentioned, and it's an agreement between the parties, basically, under the rules of South Carolina. It's not the length of time you live together. It could be a very short time. It could be a very long time.
So you're certain that somebody should know the laws before they enter into any of these relationships? Especially if you could be held accountable for it in another state. Let me ask you this, just to, I know it's just another moment that we have left. Do we have palimony here in New York?
This was not a palimony case, and that's where people mistake this case. This was not a palimony case. There is a lawsuit coming up in this state. I forget who the people are involved, saying that someone promised me to support me for X period of time.
That's more like
or
a
something.
contract.
A contract. And in that sense, if that could be proved, perhaps you could do something. But no, we do not have palimony as you would commonly understand, or as your audience would commonly understand the term. I shouldn't say you, since you're a lawyer.
Okay, let's get back to the topic here. In the moment that we have left, small claims court. Is it for everybody?
Small claims court is for everybody, and you can have the most interesting kinds of cases. I mean, a dog biting another dog and the person suing for property damage to his or her dog, or you have some very interesting cases. The cases on these, what do you call these investments on these planes, the letter investments, the gambling kinds of things.
Oh, yes.
Those things. There are all sorts of cases.
Is that like the junket if you will fly to Florida, if you come down and you get to Florida and there's nowhere to stay?
And then your luggage lost on a plane, too, under the Warsaw Convention, whether you could get the full value of your luggage or only what the Warsaw Convention
We're going to have a separate show on Warsaw Convention. Judge Silverman, thank you very much for appearing on Lawline. And as always, thank you for watching Lawline. This is Alan Schnorman.
You have been watching Lawline with your host, New York trial attorney, author and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Lawline, 27th floor, 63 Wall Street, New York, New York, 10005.